Hello everyone and welcome to Lawminds. So today in this particular video we will be dealing with the topic the salient features of the Designs Act 2000. So under this topic I will be explaining in detail what is the Designs Act 2000, why is it legislated, and what is the importance of the act, and I will also be discussing about its origin and the definition of the terms designs under Designs Act 2000, and finally we will be discussing each and every one of the salient features of the Designs Act 2000 one by one. So let us start the video. First of all, let me give a brief introduction regarding the topic. Okay, so we all know what are intellectual property laws, right? Our Indian law recognizes and protects intellectual properties. So there are different types of intellectual properties. There is trademark, there is patent, there is copyright, there is design, there is geographical indication of goods. So all of them are intellectual properties, and all of them are protected under the law, both in Indian law and in international law. So these laws for each and every intellectual property, they are collectively called as intellectual property. They are collectively called as intellectual property laws. Okay, so in India, there are a variety of legislations protecting the intellectual properties. There is Trademark Act 1999, there is Patent Act 1970, then there is Designs Act 2000, which we'll be discussing in detail now, and then there is Geographical Indication of Goods Act 1999. Okay, so when it comes to designs, first of all, what is this design, or what comes under this Designs Act 2000? What is protected under the Designs Act 2000? Okay, for that we have to understand what is this design, where is it applied. So the designs are applied on an article. Okay, an article means a product. Like when we go to a shop, we see a product and we instantly get attracted to it and we buy it. Okay, the consumers tends to purchase the item solely because it has an eye-catching appearance. At the time of purchase, people are attracted by a design which has an artistic merit. Okay, which has an artistic merit, which means that the designs are under Designs Act. Those designs are protected which are applied on an article or which are applied on a product and which has an artistic merit, that is, it is eye catching, and it is the effort or it is the hard work of a person or the proprietor or the designer by putting much thought, time and expense to find a design for a particular article. Then why is this design very relevant, or why is it very important? Because when the design is eye-catching, or when the appearance of a product is good, appearance of an article is good, there will be more purchase by the consumers. Like we oftentimes we go to a store and we see a product, we are instantly attracted to it and we buy it. Okay, so this will lead to increase in profit, because this will lead to increase in sales and this will lead to increase in profits. So the producers of a particular product or a particular article often hunt for an attractive design to their products, which will increase sales. Okay, so hence such designs need protection of law. This is the reason why designs need protection of law, so that no one else can steal it or no one else can apply it on their product for stealing the profit, okay, out of the original owner's work. That is why the Designs Act 2000 is enacted, that is to protect the design of goods. The Designs Act 2000 protects the designs of goods. So now let us move on to the Designs Act 2000. But before moving on to its applicability and its importance, let us first discuss about its origin. Okay, so the origin of the Designs Act 2000 traces way back to the British period. Okay, the first act to protect design in India under Indian law is the Patent and Designs Act 1872. So this act supplemented the Act of 1859 passed by the Governor General at that time. So the 1859 Act or the 1872 Act was enacted to protect the industrial designs and also to protect the inventors. Then this act, this 1872 act, was repealed by the 1888 Act, Inventions and Designs Act of 1888. Now, this 1888 Act was inspired by the Designs Act of United Kingdom. Okay, then there came a 1911 Act which was passed by the British, and in 1930 there came an amendment to this act. So what changed? What was the change that happened, or what was the change that was made in this particular act through this amendment was that the registration of designs, under registration of designs, the term new and original design was changed into new or original design. Now, what is this new and original design? We'll be discussing in detail when we'll be discussing the salient features of the act. But this 1911 Act did not only dealt with the designs, but it also dealt with the patents also. Okay, so now in 1970, the Patents Act came into force. The Patents Act specifically protected the patent law. Okay, so the 1911 Act continued to protect the industrial designs till the Designs Act 2000 came into force. So until then, the Designs Act 1911 was in force in India. What happened is that in 1995, India became a member of World Trade Organization, WTO, that is World Trade Organization, and it also became a part, India also became a part of the TRIPS agreement. Okay, the TRIPS agreement, we all know it is an agreement on the trade related aspects of intellectual properties. Okay, so the TRIPS agreement, India became a part of it, and as envisaged in the TRIPS agreement, Designs Act 2000 was enacted on May 11, 2000. So the law regulating or protecting designs in India is the Designs Act 2000, and this act is to consolidate and amend the laws relating to the protection of designs in India, and it is a complete code in itself. Why is it called a complete code in itself? It has 48 sections and 9 schedules, and it is also statutory in nature, and it extends to the whole of India. So these are all the important matters, or these are all these certain matters which are connected with the Designs Act 2000. Now, I earlier mentioned that I will be also be taking, or I will also be explaining in detail the definition of the term design under Designs Act 2000. Now, section 2 clause D of the act defines the term design. Okay, so an analysis of this definition brings light the following points. Now, the first point is that in under Designs Act 2000, designs means features. Now, what are these features? The features can be, it can be shape, it can be pattern, it can be configuration, it can be an ornament or composition of colors or lines that are applied to any product. So designs are features. The designs are called features. The features of a product, or the features that are applied on an article. It can be shape, it can be pattern, it can be a configuration, it can be a composition of colors and lines. So all of these features which are applied to any particular product is called a design under Designs Act 2000. Now, this design can be two-dimensional or three dimensional. Now, the features like the shape and configuration are mainly the features that are three-dimensional, and the other features like pattern, ornament, or composition of colors or lines are two-dimensional in nature. Now, the next important point is that the design are the features which are applied to any product. Now, how is this features applied? How are these features applied? They're applied either manually or by mechanical means, or by chemical industrial process or means. It can either be separately applied, or it can be combined. It can be applied in a combined form. Now, the features applied in the finished article must be appealing to the eye, and it must be capable of being judged solely by the eye. So, when we look at a product and when we see its design, we must be able to recognize the product. Okay, we must be able to judge, okay, this is this product. now I am going to buy it, or now I am not going to buy it. So this is the importance of the design, that it helps us to judge a product. It helps us to recognize a product. Now the next point is that it does not, there is a negative aspect coming here. It does not include any mode or principle of construction or anything which is in substance a mere mechanical device. It does not include anything or mechanical device which is used to apply these features on a article. It only means, or it only includes features and not those means or not those principles of construction or mechanical devices. Now, the next point is that it does not include the following things. What are these matters? What are the things that are not included under the Designs Act? The first one is the trademark as defined in the Trade and Merchandise Marks Act, and the second is the property mark as defined in IPC, and the third is any artistic work as defined in the Copyright Act. Now, these marks or these artistic work is not included under the Designs Act 2000, or does not come under the definition of the designs under Designs Act 2000. Now, the most important point is that a design under Designs Act 2000 is related to a article. Now, designs are applied on the article. It is not the article itself. Okay. Designs are those features which are applied on the article. We cannot say that the article itself is a design. Article itself is not a design. The features which are applied on that article are designs. And now what is this article? The article, it means any article which are manufactured article, or it can be any substance. It can be an artificial substance, it can be partially artificial and partially natural substance, and it also includes any part of article capable of being made and sold separately. And this article must be any article, and it must be capable of being made, it must be capable of being made and sold separately. So these articles are called articles under Designs Act. Okay, now we will be discussing in detail the salient features of Designs Act 2000. Okay, so these are the 10 salient features that are discussed in this particular video. Now we will be discussing each of these 10 classifications one by one in this. Now, the first salient feature of the Designs Act 2000 is that there is a classification. What is this classification called? It is called the Locano classification. Now, what is this Locano classification under Designs Act? That is, the Designs Act 2000, in this particular act, there is an introduction of a classification system. Now, previously, this classification was based on the material which has been used to make the article. Now, this classification is based on the subject matter of the design. So, there is a classification under the Designs Act 2000, and it is based on the subject matter of the design. Okay, now the second feature is that there is a requirement of registration. That is, there are a few requirements for a design to be registered under this particular act. So, the first requirement is that the design must be novel and it must be original. Okay, so the design must be new and it must be original, and it must not be previously registered design. So if it is a previously registered design, then it cannot be registered again. That is, it is not original and it is not new and it cannot be registered. Okay, now for a design to be considered suitable for registration, it must be unique, and a combination of previously registered design can also be considered only if the combination produces new visuals. Okay, so there must be some novelty in the design for it to be considered for registration under Designs Act 2000. Now, the second requirement is the uniqueness of the design. Now, what is this uniqueness? It means that the design must not be already published. Okay, the design must not be published under any platform, and there should not be any tangible copy available already in the market in the digital format. Now, the secrecy and a private use of the design is not publication under the Designs Act 2000, because the proprietor can use this design in secret and in private for experimental purposes. So, this purpose for using using the design for this experimental purpose, it does not come under the term publication. Now, there is a case law, Chem and Company versus Prima Plastics Limited. So, under this case law, it was held that the disclosure of the design to any third party cannot be claimed as publication, provided that the disclosure must be in good faith. Okay, so under this case, it was held that if you are discussing or if you are disclosing the design to a third party, it cannot be claimed as a publication. Cannot be made a publication, provided that the disclosure must be made in good faith. If the disclosure is not made in good faith, then it might become a publication. Now, the next requirement is it must be applied in an article. There must be a application of the design on an article. Okay, so the application of the design should be made on the article itself, and this is the next requirement of registration. Now the last requirement is order and morality. Okay. Now the design which can cause a breach of peace or may hurt the sentiments of a person may not be allowed to get registered. So it must not be in contravention of the order and morality. Now there is a provision of certificate of registration. Whenever a design is registered, whenever any intellectual property is registered, there is a provision of certificate of registration, and we will be receiving the person who registered such an intellectual property. In case of design, the person who registered the design will be receiving a certificate of registration, which provides this certificate of registration will effect certain rights and certain liabilities on the person who registered such design. Now the next feature is the copyright in registered design. Okay, this particular feature states that the registered design holds a validity period of 10 years. Now whenever we register a design under the Designs Act 2000, the validity period of such a registration will be 10 years, and it can be renewed for 5 years after the date of expiration of this 10 years. It can be renewed for another 5 years, provided that such an appeal for renewal must be submitted during the 10 years of the registration. Before the date of expiry of this 10 years, the submission for renewal must be made. Now the next feature is the provision of restoration of lapsed design. Now, when we have already discussed this copyright in registered designs, so a design that ceased to have effect as a result of failure to pay fees for the extension of copyright, the proprietor of such design or his legal representative may, with the permission of the controller, make an application for the restoration of a design within 1 year of the date on which the design ceased to have an effect. Now, what this feature states that we have already discussed the copyright in registered design. So, we are the after the date of expiry, we forgot to submit the application for renewal for the next 5 years. Okay, so after that time, the design will be ceased. If we do not renew it, then the design will be ceased to have effect as a failure to pay fees, or if we forget about the extension. Then in such a case, the proprietor of such a design or his legal representative may, with the permission of controller. Now, who is a controller? What are the powers of controller? We'll be discussing in detail. So, with the permission of a controller, the proprietor of such design or his legal representative, they can make an application for such restoration of a design within 1 year of the date on which the design ceased to have an effect. Okay, now the next salient feature is the elimination of secrecy period of 2 years for a registered design. Now, in earlier laws, there was a provision where there is a secrecy period of 2 years after a registration of a design. The design can be kept secret for a period of 2 years. Now, under the Designs Act 2000, such a provision is not there. It is revoked or it is eliminated. Now, the next salient feature is the provision of public inspection. Now, any person can inspect. Any person can get a certified copy of the license of a registration, and he can also inspect the same and raise objections if any. Now, the next feature is the regulation of anti-competitive practices. So, under the Designs Act 2000, there are provisions regarding the avoidance of certain restrictive conditions, and there are also provisions to regulate anti-competitive practices in contractual licenses. So the next, then another important feature of the Designs Act 2000 is the piracy of registered design. Now, what is piracy of registered design? It simply means the infringement of designs right. Okay, so it can be made by any false or evident replication of a registered design without the proprietor's authorization, or it is the importation of such material that closely resembles a registered design. In both of these cases, there is an infringement of the designs right, and it is illegal also. And in such a cases, it is a civil case. It will be a civil case, and in such a case, a compensation must be is payable for such infringement, and it shall not exceed rupees 50,000. So a sum or an amount not exceeding rupees 50,000 will be payable by the infringer for such infringement made. Now the next feature is the transfer and appeal to High Court. So under this act, under the Designs Act 2000, this act allows the district courts to transfer or to appeal to the High Court where there is jurisdiction. So the High Court who have the jurisdiction, to such High Courts, district courts can transfer the design infringement cases, but it is possible only in cases where a person is challenging the validity of registration. So only when there is a person challenging the validity of registration, in such a case only this transfer of appeal can be made, and in no other cases. Okay, the next is the power of the controller. Now, the controller is an authority under the Designs Act. So he has the same powers. He has the same powers as that of a civil court. Now he can receive evidence, he can administer oaths, he can enforce the attendance of witnesses or compel the discovery of production of documents, or he can issue commissions for the examination of witnesses. And he can also grant rewards, and these rewards will be having the validity of a decree of a court. Okay, so he has all the powers, or the controller has all the powers of a civil court. And any person who has any agree, or who is any grievance, or any person who can file with the controller for the cancellation of a design's registration on any of the ground that makes such registration unregisterable. So if a person files a petition before the controller that the design is not new, or it is not original, or it is already published, in such a cases the controller can do some investigation, or it can call for documents, and then if it is true and if it is not unregisterable, then he can cancel the registration of such design. So these are all the salient features of the Designs Act 2000. Now to conclude, the Designs Act 2000 aims to nurture and support designers. Okay, so it protects the designs, or the protects the designs and the designers in India. So I already mentioned why design is very important, or why the protection of designs is very important, because designs of a product is very important in the business perspective, in the management perspective. It is very important to boost sales or to increase profit. So an infringement to the designs, or an infringement to the Designs Act, or the rights of a person, or the rights of a designer, will be affecting the profit or the goodwill or reputation of such business, and hence the Designs Act 2000 is very important. And it also, there is the provisions of the Designs Act 2000 also provides for remedial mechanisms and appointments of authorities like a controller, so which further protect such protection. Okay, so that is why the Designs Act 2000 is very important. So I hope this video is useful. Thank you.